a landmark victory in the Supreme Court, which confirmed that sex and woman in the Equality Act were defined by biology. Susan contributed 2 chapters to the Sunday Times bestseller, The Women Who Wouldn't Wish, and I have my copy here. It is a great book. And she's also director of Byra's Place, the Rape Crisis Centre established in Edinburgh by J.K. Rowling, and a board member of Women's Platform for Action International, a global umbrella group for women's organisations. Susan is on X at For Women Scot, and the website is https://forwomen.scot. Sally Wainwright was the architect of the lesbian intervention in the For Women Scotland appeal, which determined that sex is biological, at least for the purposes of the Equality Act. She's a lesbian activist, a co-founder of Lesbian Persistence, and a serial creator of women's spaces. Sally co-edited Women's Rights, Gender Wrongs, the global impact of gender identity ideology.
Around your house, any of that.
Can you mute, please, ladies? And contributed a chapter to The Women Who Wouldn't Wish, discussing the attempt by trans activists to shut down the Audacious Women Festival, which she founded. She tweets on X at Lesbian Persist, and the website is www.lesbianpersistence.scot. Dr. Lucy Hunter Blackburn co-edited The Women Who Wouldn't Wish with Susan Dalgetty. The book captures an important moment in contemporary history, how a grassroots women's movement took on the political establishment and changed the course of history. In over 30 essays, some of the women involved, including the 2 other panelists this evening, tell the story of the campaign to protect women's sex-based rights, up to the point where it plays a part in the resignation of Nicola Sturgeon. Lucy and Susan have just launched their follow-up project, a fortnightly feminist online publication on Substack, The Front Line. It's great. It's easy to subscribe. Lucy also works with Murray Blackburn Mackenzie, a group of 3 women based in Edinburgh who've spent the last 6 years analysing, recording and trying to influence developments in policy, law and practice around self-ID, with a focus on Scotland. In a previous life, she was a senior civil servant in the Scottish Government. You can find her on X at Lucy Hunter B, and the MBM account is at MBM Policy. There's also at Ethel Rights, which is how you get to the front line, and that's at https://frontlinewomen.substack.com. We'll be putting these links in the chat as we go along. And also you can see the website is at murrayblackburnmackenzie.org. Welcome, Lucy. Thanks for stepping in at short notice. The book, to which all of you contributed essays, has become a bestseller. I can recommend it. It sequences the twists and turns of Scottish Government gender policy and their disdain for ordinary women. Perhaps you can outline for us how the resistance has developed.
Right. So thank you so much. You've done my product placement already, but I'll advertise the paperback, just for those of you on a tighter budget, which came out in March, just around International Women's Day, which was great. So I suppose the question really is, why is the first book to come out of UK women's campaigning about Scotland? Because there hasn't been campaigning across the whole UK, but there is a reason, I think, that we ended up writing or editing the book. So I'll talk a bit about the background to Scotland, what makes it different up here, and then a bit about how we came to do the book. And then I'll pass over to Susan and Sally for the sort of hard, raw facts about what it meant to do the case. So Scotland is different for one big reason, is that we have the Scottish Parliament. And that was founded in 1999. And it landed in a world where we already had a separate sort of lobbying environment around gay rights, and different organisations that were set up here. One in particular, very important to this story, is the Equality Network. And that grew out of a range of other gay rights campaigns in Scotland over the 90s, but was set up specifically to take advantage of the creation of the Holyrood Parliament to advocate for gay rights. And we needed that in Scotland as elsewhere. Probably a more socially conservative, well, definitely a more socially conservative place later to decriminalise male homosexuality. So on, Sally knows this story far better than me. So the Scotland had this different political microclimate right from the very start. And it's important to say that trans rights, if you like, transgender rights, self-ID quite specifically, is built in to the platform of the Equality Network from 1999. As Susan's opening, well, Susan and I's, but Susan did most of the donkey work, opening chapter shows. And we have other things that are different. Stonewall has a different branch up here, Stonewall Scotland, which also is more committed to self-ID right from the start. Right from the start in 1999, 2000. The LGBT Youth Scotland will be an organisation many of you have heard of, again, very much embedded in this in this debate. So there's a movement quietly bubbling away in Scotland, which is also there in England. You have Press for Change and you have other organisations. In Scotland, it's different though, because it's very intimately embedded in lobbying around gay rights from a long time back. So that makes us different, first of all. Then we have the Parliament. Then we have the independence referendum in 2014, which doesn't succeed and leaves a kind of vacuum, a political vacuum in Scotland for what's going on. And the Parliament, the Scottish Parliament, always wants to prove that it's more progressive, more nice, for a better word, than horrible England. So in the Equality Network in 2016 lobbies right across the board, across all the parties, to have gender recognition reform, but self-ID quite specifically brought in. And many of the parties, not, in fact, ironically, not the SNP, but the Liberal Democrats, the Labour Party, the Green Party, absorb it in their manifestos. The Labour Party, the SNP has something a bit more cagey, although they are in the end the cheerleaders for this, the main leaders. So this is all going on, and at the same time, Alex Salmond resigns in 2014, is replaced by Nicola Sturgeon, who comes in really with no big support base in the party. You know, she's very much his protege. She's come up under his wing. So she needs to establish herself politically as different, new. She wants to cultivate a youth base in the party. There's a very big and a lobby we none of us really understand well enough called Out for Indie, which comes along, and they're very influential and still, I think, very influential. So all this makes us different. And then, of course, we then have the legislation. So as England, the legislation here was never meant to peel us off England. It was, it was meant to go along with what Theresa May and others were promoting in England, Miriam Miller. But instead, they consult women in England, get there, you get your act together very spectacularly, and the legislation doesn't go anywhere. Under the Tories, it's Liz Truss bins it. But we carry on because Nicola Sturgeon's very, very committed. There's another election in 2021, and then the rest of the story. So what the story told in the book, the reason Susan and I wanted this was that it was an extraordinary 5 years running up to Nicola Sturgeon's resignation. Sturgeon was absolutely dominant here. I mean, it's really quite hard to imagine. There's been nobody like her in the English political scene, I really don't think, in the same period. So she's very dominant, unassailable, utterly unassailable figure. And when she goes, it's not just because of this. I don't think any of us would claim that, but the fuss around, particularly Isla Bryson, it weakens her. It makes her look, suddenly for the first time, really the first interviews we have ever seen her do, where she looked a bit shaken and off her script, were on this subject. And it's that kind of contributes, and obviously other things are going on. But so we felt when we realised there was this amazing 5 years from the first meeting in Edinburgh, almost to the day, to Sturgeon resigning, that it was worth capturing this, because we knew one thing would happen if we didn't. Other people would write it. They'd write the big political history of Scotland, and they would leave us out. They would leave out the role of women. And once we decided the story needed to be documented quickly while it was still fresh and get our voices in first, the only way to do that, we thought, that was sort of reflected the campaign, was to bring in as many other women as we could to write their own stories firsthand. So the book is very deliberately a compilation of first-hand accounts with a bit of framing at the beginning by Susan and me and a bit at the end. But we wanted the body of the book to be a historical document, if you like, which records women in their own voices, because that is so important. And the history of women generally is not well told. It's so often talked over, retold, men get the glory, all the usual stuff. So that's the background to the book. And obviously a key theme through the book, why Susan is the only contributor to get 2 chapters, is the court case, which just runs throughout large parts of the history the book covers. And that, you know, that's very important. The other thing I want to say is that it's also conscious it's Pride Month, and we have Sally. It's a book where 1/4 of our contributors are lesbians, and we are especially proud to say that, you know, and there's a reason for that, which Sally will explain. Well, it's not the only reason, but is that this is an issue of where lesbians have been massively important in the front line of campaigning, and we didn't sit down and think, right, we better make sure that it just happened that way. That when our list of authors, when we put them together, came out. So that's my spiel. I'm sorry, it's a little bit raggy because I've stepped in a bit last minute, but I hope that scene sets for what Susan and Sally are going to talk about now.
Yes, just before we go on, Lucy, I read that, I think the afterword, you know, you mentioned there that some political commentators said, oh, of course, you're going to have to write both, you know, balance it with both sides. And I thought, what? How dare he?
Okay, but this is a great story, because early on we didn't know if we get a publisher, because we're sitting down with this list of people we'd like to ask to write. We've got quite a few of them we've asked, some of them we haven't asked yet. We haven't yet asked, or at this point, I don't think we quite sent the email out to J.K. Rowling. But you know, we had our list, so we explored with a publisher that was active up here, we thought might be interested. And we had such an interesting meeting. He gave us a huge amount of time to say no. But he was obviously very uncomfortable with the amount, you know, it wasn't a comfortable situation. And he said, well, I think I'll give you some advice as to how you might get published. Somebody else might take you, but you really need to tell both sides of the story. And we just looked at each other. And as we say afterward, we just looked at each other and went, I don't think so. They can tell, and they have told their side of the story. You know, Trans Britain exists. It's an incredibly useful book. Anybody in this area wants to know. 2018 Trans Britain, Christine Burns is a, you know, if you want the first-hand account from their side as to what they did, it's really useful. So it was an amazingly, it kind of vindicated to us that we needed to keep ploughing this particular furrow, because if we didn't do it, it just wasn't going. Our side of the story was, as we've seen, it's been persistently misrepresented. And one of the things I'm proudest of about this book is it's permanently out there. You know, it'll be on library shelves and in bookshops and on people's personal bookshelves for years, with the story in our own words, not misrepresented, not relensed in some way by some other person. It's there, and I'm very proud that it's out there in the form it is.
Yeah, you've got a chronology. I mean, in the back, obviously, you've got all the contributors. You've got a timeline of all the laws and the debates and the hearings, which is really useful, you know, if you're trying to get up to speed on this. But actually, the most of it, the body of the book, is women talking from their own experience.
Yeah,
and it's so powerful that, you know, ordinary women we haven't heard of before. Some of them, obviously, quite a few of them we have. For various reasons. There are maybe already published authors or commentators like yourself, Mandy Rose, but ordinary women who are just getting on with things, being stopped from wearing a scarf, you know, obsolescence rights. It's simple little stories like that that give you a kind of shines a light on somebody's experience of actually being oppressed in the parliament, which is their own parliament.
It needed to be told, and one of the reasons when we've gone on to do the front line, so that the front line is fortnightly, and its key element, it's going to have a couple of pieces every issue, which what we're calling Women on the Front Line. And again, it's stories, and what we're saying to people is, come to us with stories. It doesn't need to just be about this campaign or self-ID. We're interested in women's stories about, you know, aspects of women's lives now, and campaigns for women's rights in the past. But storytelling is really powerful, as in fact the other side of this argument have demonstrated often. Storytelling is powerful, and policy analysis, which is my other piece of work, is really important. We need to do it, but we need to tell stories as well.
And this is focusing on Scotland. Somebody listen to the archers. Can you mute yourselves, please, ladies and gentlemen? Thank you. I think you'll find that we'll find that it's going to be focused through the lens of Scotland.
Yeah, I mean, Scotland, well, we start from Scotland, but we're very keen not not to feel that that's our only interest, because this is an international problem. It's, you
Right.
know, what we're
Right.
dealing with, and women's right. You know, if you look at surrogacy, or you look at prostitution, or, you know, all the big themes, they are international, and they're often internationally lobbied against us. So
Yes.
we need to talk. So we are, you know, we're looking out for. We're talking to women in other parts of the world about things they want to put in front of an audience here. We're you know, very happy to take stories from around the UK. So, you know, we hope as a reader we can appeal to a readership. Yes, we're rooted here, as is the book, but we're rooted here, but we want to appeal to a readership and connect to readership, which is across the UK and further afield. So that, you know, that's an important part for us. So thank you for asking that question.
Fantastic. Thank you very much. And that's a really great introduction to this evening's events. I'm going to turn now to Susan Smith. Now, Susan, you know, can you give us a brief summary of the range of court cases and the fights that you've had to undertake in, let's say, the past 5 years, but it's going to be a little bit longer than that, isn't it?
Yes, so it's been five court appearances, 2 judicial reviews. And the background to this was a specific piece of legislation. And people have said to me, why Scotland? How did this come about? Why this piece of legislation? And I think the answer to that really is because they wrote it down in this case. And I think that a lot of the time, these definitions around women and who's included have been left very open-ended. So organisations have been given all this advice on law by lobby groups like Stonewall. They've come in and said, if something refers to women, you're supposed to include trans-identifying men in there as well. But in this piece of legislation, which was a very obscure piece of legislation, it was about gender balance on public boards in Scotland. And it just set out in terms that the definition of women was based on self-identification. And it also made it very clear that this self-identification model was hugely wide open to all sorts of abuse, frankly, because it didn't require any effort on the part of the individual in question. They might have changed their name, they might have changed their pronouns, etc., but there was absolutely no onus to check. It was just purely on self-declaration. And this was really deliberate because initially the bill had just referred to women, and it was said that it would adhere to the definition in the Equality Act. But during committee stages, what we had was Scottish Trans Alliance, who Lucy's referenced, came in and saw this as a bit of a test ground because, of course, the Scottish government were already speaking at this point about bringing in self-identification for gender recognition. So I think they saw this as an opportunity to test that. And they asked the committee, I think there were only 4 people on the committee, to change this definition. And it passed through the Scottish Parliament because, of course, at this point, 2018, the beginning of 2018, there was not a lot of noise about this. You know, women's organisations had formed and we were talking, but there wasn't really much public-facing stuff. I think in the book, it talks about some of those early meetings that women had, including the one in Edinburgh in 2018, about the same time this bill was passing through the Scottish Parliament. And the levels of intimidation and fear were pretty extreme. So it passed, no one noticed. My colleague Trina noticed, and she wanted to do something about it, but at this point, For Women Scotland wasn't even in existence. We formed about 6 months after the bill passed. We had no money, we didn't have a lot of influence. But by the end of that year, when I was appearing at committee to talk about the census, Scottish Trans Alliance and the Equality Network were already citing this act as setting a precedent for allowing people to self-identify their sex. So we knew it was a problem. And then in 2020, there was a a follow-up consultation, and we thought that we might have the opportunity to challenge it. We thought it had timed out, but because of this additional consultation, we thought there might be a window. So that was when we launched our first judicial review. As many people will know, we lost, first of all, in the outer court, which is the lower civil court in the Court of Session, but we won in the inner court, which is the appeal court. And that ruling set out very clearly that self-identification was not lawful, that the Scottish Government had exceeded their competence, and that provisions for women excluded biological males. And it was very clear, and it didn't actually refer to people with GRCs. So when it went back to the Scottish Parliament, they had to strike out the faulty definition, which they did do. They had to pass another piece of legislation to do that. But they then also issued statutory guidance, which said that this included people with a GRC that said their sex was female, and excluded people with a GRC that said their sex was male. And again, this was one of the first times it had been spelt out in law that this was what was presumed to be the case. We'd been arguing around the houses on this for a very long time, because obviously, as gender recognition was passing through the Scottish Parliament, there were a lot of people with their own views on the extent a GRC changed someone's legal status. And that had become a big point of contention. And what we found then, that the Scottish Government were quite happy to hold two completely contradictory points. So we felt we had to challenge them, because if nothing else, we were going to push this out into the light and make sure we all knew what the legal basis was. So during the passage of the Gender Recognition Reform Act, the Scottish Government were saying that a GRC made no material change to anybody's legal status, and it was just a piece of admin. And in court, they were saying that it changed someone's sex under the Equality Act. So, of course, we then lost twice in Scotland, and we had to take the decision whether or not to take it to the Supreme Court. It was quite interesting that there was absolutely no resistance, either within the Scottish courts or from the Scottish Government, to us taking it to the Supreme Court. I think possibly because by this point, everybody felt that we actually really needed to have an answer to this. And, you know, while I would have liked very much to have won earlier, in some ways, having it at the Supreme Court got that attention, not just in the UK, but across the world. But it's been very interesting that obviously our first win had had very little impact, because having established self-identification was unlawful, you would think that organisations would have no problem in dealing with this very small number of people who have GRCs, who are now also not included in their adopted sex. But obviously, organisations had continued to act on the basis of self-ID even after we'd won our first case. And we felt that even if we lost, one of the things that was very pertinent was that the EHRC had made it very clear that they felt this was the case in law, but it was confused and it was causing problems, and it was impossible to operate the Equality Act with this strange in-between category. So we felt any loss would mean that a recommendation that this had to go back to Parliament, which we thought actually probably a lot of politicians at Westminster and back here were probably hoping desperately we did win, so they didn't have to disentangle this themselves. So I think that's a bit of a whistle stop tour through that. But I would just say, you know, the speed that this was enacted and how thoroughly society was captured by this ideology has been extraordinary, and we've seen it in the resistance to the ruling. So many people just saying they're not going to obey the law. And I do find that really troubling. The idea that this is a vulnerable and marginalized group, it's nonsense. I don't think any vulnerable and marginalized group would have had the capacity to upend law and society so thoroughly as gender ideology has done. So we've still got to fight. And obviously, thankfully, J.K. Rowling has set up a legal fund for women who have faced discrimination at work and so on. So I think we will have to keep taking people back to court. It's not over yet, but hopefully this is the beginning of the end.
Well, it is, but there's going to be some other thing they're going to think up, don't you think? Because,
yeah.
I mean, they had the procession of the gender recognition reform bill going through, ignoring women all the while, completely ignoring any possible safeguarding issues. And thankfully, when it was passed in Scotland, the Scottish Secretary then came in with the Scotland Act, and what did he do? You know, he made a big difference there, didn't he?
Yes, he did. And that section 35, I mean, I know plenty of people who were die-hard independence supporters who at that point were going, thank goodness we don't have independence, because that wouldn't have happened.
No.
And it's one of the things that's been much discussed on this. I think, you know, our cases were really important for the Section 35 in the sense that it had generated the publicity, and it had generated enough concern down in Westminster to think this is justified. A lot of people have subsequently said that because we've now won, they should be able to bring it back. But I think the issues with allowing a two-tier system of gender recognition in the UK go beyond concerns about what a GRC does to somebody's status under the Equality Act. So there are plenty of other issues within there that justify the Section 35.
And this has taken a huge amount of time for the Scottish Parliament, hasn't it? And for the administration, if you like, to manage, which they could have been.
And money.
Yeah.
And you know, that during the gender recognition debate, it was extraordinary, the late night sittings, which were unprecedented, and this parliament that had been touted as more family friendly sort of environment to Westminster just jettisoned all that to push through this awful, unnecessary legislation. And I think you're still, you know, Patrick Harvey was selected for an urgent question to talk about toilets in the Scottish Parliament the other week. And when we think, you know, Scotland still has the worst drugs death in Europe, why is where Patrick's assistant goes to the loo is the most pressing question in Scotland that day? I find it extraordinary.
Yeah. And so far, I mean, according to I think it was Ben Cooper who found the number of 8,464 up until last autumn gender recognition certificates across the whole of UK. A tiny number of people, and the furore about this all. And yet, it's not a tiny effect, is it? It's a massive effect on women's capacity to be in the public realm.
It is. And of course, you know, it was never really about just that small, because the other people, the hundreds of thousands of other people who were just self-identifying, were using that to get in through the door. So they were, and it's something, you know, that the judges picked up, that you ended up with a two-tier system within people who had who were under the category of gender reassignment.
Yes.
That there were some people who were indistinguishable in the amount of work or surgery they had, or indeed hadn't done, one of whom could be considered legally a woman and the other one is still legally a man, and it was an absurdity.
Yeah. And the act that you reviewed, the 2018 Act on getting more women effectively into public life and on public boards, the upshot of it would be that you could have 50% of the public board appointments being males, and 50% of the appointees could be trans-identifying males. So 100%.
And a Scottish MP, Kirsty Blackwood, said that she would have no problem with that sort of scenario, which is, I do despair about the quality of our elected representatives at the moment.
Our past president of our party, Baroness Sal Brinton, she answered the question at a Fawcett meeting on, would she be happy with that? Of course, because of course trans women are women. I mean, the idea that would be a good thing to have 100% male-bodied people, especially when an act here is supposed to be providing for more opportunities for females, it's just unconscionable, isn't it?
It is. Well, I always say, I always give the example of, it was always huge furore back when I was younger, and we knew what a woman was, and when people were talking about abortion rights, they'd often say "no uterus, no opinion," and comments like that. And I remember the picture from America of a room full of men deciding, making laws about abortion, and women being very upset about that. And I said, but in the future, you would have no right to be upset about a room full of men making decisions about abortion, as long as a significant proportion of those men claim they were women. Because if that's your definition of women, you can't object to that. And it just seemed to me ridiculous that if men say they're men, they shouldn't. They are somehow a danger. This is the other thing. They're a danger, or they don't understand. And the minute they just say, "But I identify as a woman," all that apparently magically disappears. I think the world is more nuanced, but equally, sex is not nuanced.
No, it's not. It's absolutely categorical, isn't it? And we can spot it almost instantly.
Yeah.
Oh,
and the other thing, yes, that I think was very key in the absurdity of listening in the Supreme Court. One of the things, I know Sally's going to talk about the lesbians and the idea of the lesbian couple and how that was discussed. I'm sure she'll touch on that. But it was the conversation about the pregnant man, and how you could, and the inner court's solution to this was that at some point the word woman in the Equality Act means a woman, but in other points it means a woman, and some men, and the Supreme Court said that's ridiculous, you can't have this. And of course, this was one of the absurdities with the pregnancy and maternity. And then we had the necessity for flowcharts to explain lesbians.
It was quite embarrassing listening to the tribunal tweets, to the goings on in the court, and reading tribunal tweets talking about it. The barrister, the junior, if you like, to the Casey, didn't seem to have it quite at her fingers' ends, and it was like the slow motion car crash, wasn't it?
It was, and of course there was no one from the Scottish Government in court. So if something came up from our side, we were sitting behind our solicitors, and the other interveners were in court, and we could all scribble things down and pass notes through to our KC. And of course they didn't. They were having to say, "Well, we'll check at lunchtime." They were really left swinging in the wind by the Scottish Government.
And at the same time, they were saying things in the Supreme Court which the Scottish Government, had been denying. You could hear that gasp around the room.
Well, it was the same day that they were having the conversation about pregnant men in court. A reporter asked John Swinney, "Can you have a pregnant man?" And he said no. So And I think at the break, our solicitor, who knows the KC for the Scottish Government quite well, she said, by the way, John Swinney's just said there's no such thing as a pregnant man. And I think the expression on the poor woman's face, she was clearly thinking, what have I done to deserve these clients?
But, to hear the claims made in court and to know that they're quite the opposite was being said, for instance, GRR bill. Oh, no, it's just admin.
It's just, yeah.
The court case was how crucial it was to the operation of the Equality Act and the various gender bills that were going forward. It was staggering, really, that there was this double take, but you had that rapid rebuttal capability that they did not.
Yeah. Yes.
So you'd think that somebody from the Scottish Government could have actually come down and made the effort. They might have been a bit more successful, do you think?
I don't think so, because I think once they'd started to have ridiculous arguments about pregnant men and flowcharts for lesbians, I think the absurdity of the thing is, somebody made the point that you could, if you really wanted to, pass law that resulted in absurdities, but there are standards, so actually they would then be struck down.
Yeah.
So what the Scottish Government were effectively arguing was that the Equality Act was passed in a way that was going to sow chaos and confusion. And I think the Supreme Court rightly said that no, that's not how statute is supposed to work. You can't have a law that just creates inanity.
No. And reading the briefs and the speeches for the case, it's clear that all the lawyers, well, certainly on your side, I didn't take much account of the other ones, but all your lawyers were saying how important it was to have clarity, consistency, reliability, understanding that a meaning of a word is the meaning that you normally take of a word, so that we ordinary people, okay, with our lawyers, but we can understand what a statute says, and we won't be bewildered by the nonsense that could be coming out of it. And I think that's a really important point.
It is, because at the end of the day, if you are running a single sex service, somebody has to make a decision, and you cannot have, say, a 17-year-old girl on the desk at reception at the gym who's faced with a 6'2" bloke and has to say you can't go into the ladies, and she basically has to take out a legal dictionary in order to justify it. It has to be obvious.
Clear. Well, it's the same as the Saturday girl in the changing rooms, where people going in to try on clothes.
Yes.
That's at the point of contact, isn't it?
Yeah.
The Saturday girl.
Yes.
Saturday girl.
and
responsibility.
It is. And when we were having the arguments around GRR and going to the committee, I mean, that was almost essentially the Scottish Government's position, that, well, we're not actually sure, but you know what, somebody on the desk will sort it out. No, they're being paid peanuts. You're getting, 80,000 a year. Sort it out.
Now, what a question I've got is, I'm not entirely sure, does the Supreme Court judgment change what the Scottish Government can do in appointing more females to public boards? Has it worked as it should have worked in the first place, or has the whole thing been, they salted the fields, if you like?
No, I mean, that act has passed. The statutory guidance needs to go, but that act has passed, and the act now says 50-50. It was an interesting one because actually public boards were pretty gender balanced anyway, so it was an odd one to have. But it does mean that any future measures taken by the government or anybody really, if they refer to men and women and their anti-discriminatory measures, they have to mean men and women. One thing that has resulted from this is that the Scottish Greens, God bless them, have now changed their policy for their list candidates. So they had a zipping system, which was men and non-men. And they obviously now have been told this is unlawful and liable to challenge, because they always included non-binaries and trans anybody into the women's part. And so they've just scrapped it. They've just wholesale scrapped it and said, right, we're not going to have any positive measures at all, because clearly if you're forced to have a positive measure just for women, that's not on. Although they've maintained it for their leadership candidates, which
Oh,
is
really? That's interesting, isn't it? A bit like heirs to the throne can be sex neutral in succession, but not just ordinary peers.
yes.
Anyway, that's another story. But my next question was going to be about the complaining. You mentioned that a lot of people have said they're not going to comply. Robin Moira White on Woman's Hour said he was going to carry on doing what he's always done. An officer of the court. Extraordinary. But there's been a large number of activists of various places complaining about the judgment who's obviously never read it. You know, the Amnesty guy, the chair of Amnesty, was on Woman's Hour, and he kept talking about it being, 30 pages long. It's 88. I mean, it's not over long. It's all readable, but it's not 30 pages.
And he said it 3 times, so it wasn't just unless he'd read it in sections of 30, three sections of 30 maybe. But yeah, that was embarrassing.
Well, he was inarticulate, to be fair.
It's trying to speak with authority on the ruling, and it was also embarrassing. No one from Women's Hour pushed back and said, well, clearly you haven't read it, because you don't even know how long it is.
But they don't know either. They're not interested, and they're on their side anyway, so they're not going to push back. I mean, they did. They kept saying to Helen, and I think to you, maybe LGBT Alliance, isn't that offensive when you were speaking proper language about actual sex talk, about people's real sex? Isn't that offensive? They never said that to those people.
No, and I find it offensive that Robin White thinks that he's going to continue to use ladies' facilities, but there we go. And and this whole thing about toilets is something of a red herring, because they're banging on about checking nobody is going to be checking your passport or your birth certificate on the door of the toilet, just as no one checks your driver's license if you get into a car. But if the police spot someone who looks like they're 12 driving a Range Rover down the road, they will probably pull them over. And in the same way, if somebody who looks like Robin White, frankly, goes into the ladies, you will know that they shouldn't be in there. So, it's a bit of an absurdity. And, frankly, if they pass, I'm not sure they are going, but a lot of them are quite deluded about how well they pass, I suppose.
Indeed, that's the thing, isn't it? And the other question is, are women going to be confident faced with a 6-footer in saying to them, you shouldn't be in here? Or are we just going to be doing what we normally do and get the hell out of the place before they attack us, as it were?
I think so. I think, but what it does do, it gives women the confidence to know that they could go and speak to someone in security or on the front desk and say, there's somebody in there that I think is male and
shouldn't be there.
Yeah. Whereas before, there was guidance a few years back to Glasgow Life, which runs leisure centres, saying that if a woman complained about somebody she perceived as male in the changing room, they could log it as a hate crime. So not only was she not going to get supported, she might be sent to the police. So, things like that will change, hopefully.
There are other pushbacks as well, though. I mean, Amnesty, they were talking in their brief all the time about a human rights approach to this, not even thinking that actually women have human rights too, and the balance of exclusions and exceptions in the Equality Act is there to help balance the claims of rights.
Yes, and the human rights issue is very, because obviously there's a couple of individuals saying they're going to try and go to Strasbourg. I'm not sure they'll succeed, but if they do, they're obviously intending to make a human rights argument. But things have moved on, and so now if they go and make that argument, it's not the same as it was during Corbett and Corbett, where people can get married or get pensions and all that sort of thing. They have those rights. So if they go and make a human rights case, I think what they will find is that the court will also have to listen to human rights cases about women and lesbian men and gay women as well. So they will have to consider everybody's human rights. And CEDAW, of course, is predicated on sex being biological, and that's the big international piece on framing of discrimination against women. So I don't think they can really get away with making a human rights case that is just about what they perceive as their human rights and say that overrides everybody else's human rights.
No, and that's really the point of the Equality Act anyway, isn't it? Is to balance these competing claims of rights so that you can try and be fair to people, so that people do have a fair go, but also that women's needs aren't trodden on.
Yes, and gender reassignment is in there. You know, it's still protected. This is what they felt. If they are genuinely discriminated because they're trans and they're told that there's no provision can't be made for them, then they'll have a claim and they would win that in the UK. So there's no reason then to go to Strasbourg. But they're really talking about things like people having the capacity to know their sex. But if you're in an employment situation, people, or indeed any situation, people have a right to know all sorts of things about you, your age, for example. It's not an infringement on your human rights to be required to reveal information that is pertinent in a certain instance.
Yes. And another feature that has been conveniently glossed over on the other side of the argument is the fact that the protection for trans-identifying women, trans men who get pregnant, now their position under the pregnancy and maternity protected characteristic is protected, whereas it wasn't. I hadn't realised that. But
well, it was because it was always the law, but that was the Scottish government's argument that they didn't have those rights, and there was a whole load of other acts that they wouldn't have had rights under, and this is why we say this is a very misogynistic ideology, because within that group of people covered by gender reassignment, they are only interested in the male half of that group. They were quite happy for the female half of that group to have their rights trampled on.
I think that's worth making sure we get out and talk about that wherever we can, because it has been a victory for trans men, and that's not being celebrated in any way at all, is it?
It has,
By the activists.
And I think it's one of the things that ultimately a lot of women who detransition start to find, that there is a huge amount of sexism that comes from the male part of that cohort. And I think because they feel emboldened and entitled, and because they're women, nobody can accuse them of this. So they often give free rein, and it's the same, I think, with a lot of the internalized homophobia. And there's a lot of homophobia in that group cohort as well. And I think that for some of them, it's a wonderful opportunity to be able to express opinions that in normal circumstances, most people would find pretty abhorrent.
Okay. So you don't think that the Good Law Project wanting to take a case to the European Court will prosper?
I don't know what their basis. I mean, they've taken in a huge amount of money without actually saying what they're going to do, which I think that's pretty unethical, personally. I know MacLeod and Whittle have said something about because they weren't heard. I would say, well, I have been saying, MacLeod and Whittle need to publish the submission that they made to the Supreme Court, because I think...
Oh, they did make one?
Oh, well, they made one to intervene.
Right.
So one of their arguments is that their intervention was not taken by the Supreme Court, and nobody heard any trans voices. They keep saying this, no trans voices were heard. But of course, the Scottish government was representing their position, and Amnesty. So why two individuals would have it was an odd idea that an individual's experience, and of course, no trans organisations like Scottish Trans Alliance and Equality Network,
Or
none of them,
Stonewall.
or Stonewall, applied to intervene. So, and they've been saying, well, because they didn't hear them, this is part of their case that they're claiming they'll take to Strasbourg. But
they don't normally hear individual.
The Supreme Court, no, they don't. And if they publish that submission honestly, because I have seen it, but I don't think we're allowed to.
Okay.
We're allowed to publish it because it's up to them. But I might check that, because it's becoming rather annoying, because it's really clear why that submission was not taken by the Supreme Court, because it was all about their personal opinions, and they're like. Even Whittle said in a meeting that we went to hear, Whittle, just before we got the date for the reeling. And even then, Whittle was saying, oh, well, I said, why are we doing this? Because it's not going to get accepted. So I think they were both well aware the Supreme Court was never going to take it.
It's just as a show.
About their personal experiences, and that's not law. The Supreme Court was there to make a ruling on a statutory interpretation of domestic law. It was not there to say this will make Stephen and Victoria sad.
Indeed. I heard Stephanie Davis-Arai spoke at one of our fringes, and she has said to us that she spent a really lovely summer period writing an intervention for the case that was about JIDs with Quincy, the young girl who'd taken
Kira Bell.
That's right.
Yeah.
And of course, Stonewall hadn't even sent in an intervention at all. And she on her own, with just her own resources, had managed to write something which got the hearing. And Stonewall, with a huge amount of money they've got from their US aid and various other sources, they couldn't be bothered, or they couldn't bring themselves to make a proper case. So there's a lot of things that need to be found out, really, about what's been going on, and this is just a part of it. So you think it might be published or not? Their individual case.
Very interesting. I think they should. I think if they really believe they should have been heard, they should be prepared to put out the submission that they made, that they think
that's a good point.
The judge's attention. I can't see any reason why they would continue to sit on it.
Okay, so what's the next aims for Women Scotland? What are we going to move on to now, apart from having a breather, obviously?
Well, we've not. I think now, obviously, it's trying to make sure all these organisations start to obey the law. We've started to have conversations with Scottish Government and other places, but there's a lot of feet dragging. Yes. It may take more legal action. So there's a lot to draw out, and it's gone very deep in certain organisations. But there's a lot of other issues that I think have written on the back of this and are interlinked in many ways. Here, Ash has got a private member's bill on prostitution, which
this is Ash Regan.
Yes, which we're supporting, and the other women's groups are going to be, and that I think is going to be really important. And there's a huge lobby stacked against that, because the pimps and punters lobby is massive, and it's the same with pornography. We've been looking at that with Byra's Place, and had a conference just last week where we were looking at the sort of social media harms on young women, and from this proliferation of the kind of really, really dreadful stuff that young people are exposed to now. So there's a lot. We're in this position where I think 30 years ago, if someone said we'd be fighting this stuff and it would be worse than it was then, I think we'd all be quite depressed about that. But
Yes.
that's where we are.
But you're hardened fighters now, aren't you? You're like samurai ninja, legal ninjas. So I think you've got every chance of success at some level. We've got a question here from Kate McKenzie. Kate McKenzie, I don't know if you want to ask this question yourself or you want me to ask it.
I'm happy to ask myself. Thank you. Thank you very much for organising this, and huge admiration to everybody involved in this. I have a particular interest in children's rights. So in these sort of scenarios, I'm always hopping up and down saying, and girls. And I'm not quite sure how the Supreme Court case, as I said in the question, since that was about the effect or not of a GRC, and minors can't obtain a GRC in theory, in principle, it doesn't really affect girls at all. But of course, in terms of the wider changes and the understanding of what single sex means in practice, it does seem that it will. I'm not sure whether the shift is cultural or what the legal basis is to use this judgment to shift practices and policies in schools in particular. And I just wondered if you thought about that dimension, because it's kind of the other half of this whole issue is what's happening to particularly teenage girls.
Yeah, so this is education is one of the things that we've been talking about quite a lot recently, because I'm not sure if you're aware, but the situation in Scotland is that we have this terrible trans guidance for schools, and it's dreadful. I mean, it's pure self-identification. It's based on guidance that was written initially by LGBT Youth Scotland, and ministers withdrew this in 2019 because they said that it was they thought it was unlawful and that it directly impacted the human rights of girls. But even having said that, when the Scottish government put out guidance with their stamp mark on it, it basically took the basic text of this LGBT youth guidance and just added a couple of lines along the lines of you have to consider girls as well, which was, something and nothing. So there's been a recent case which we were involved in, where these parents took their primary school to judicial review because, based on the guidance, they had been allowing really young pupils, I mean, this is primary school, to self-identify and put them in opposite sex sports, and were bringing in these unisex mixed sex toilets in their new building. And they won judicial review, but the council is moving very slowly, the school is moving very slowly, and the Scottish government will not withdraw that guidance. That guidance has not been lawful, emphatically not been lawful, ever since we won the first judicial review, because, as you say, it's children cannot have GRCs. So this was purely about self-identification, and it's not lawful. Again, I think all these things were predicated on the fact that the Scottish government fully intended to change the gender recognition, and they were going to bring it down to 16. It would have made life incredibly difficult. There was even a suggestion at one point you should be able to get a GRC at the age of 12. So I think in preparation for that, they were bringing in a lot of this stuff in schools. And of course, across the country, you have activist groups going into schools and writing material, and there's a big body of work there, and it's one of the things that we're looking at is potentially getting out some alternative guidance for schools and pointing out the law. I think it is going to be a question that probably somebody will have to take a school again back to court.
I see. Thank you. Does that answer your question, Kate?
Yes, it does. And I'm in Scotland, so I know some of the issues. I've also I do worry that it's quite ingrained through teacher training as well,
Yes.
as in teacher training colleges, not just through third sector organisations. And I still find it quite stunning that LGBT Youth Scotland is, I mean, they are still getting public money, I think, despite,
Yeah.
anyway, but yes, it's,
They
and
get
I
about
also
£1
find it,
million of taxpayers' money every year. And I
yes,
know that Thai have been going into, certainly Murray House, I don't know about, and doing the training for teachers. So yeah,
yes.
it's terrifying.
We've got a question. I'm just going to ask it for them. Do you have a hit list of organisations you want to take on if and when they don't comply with the law? And if yes, do you want to share it with us, or is that for future action?
I mean, Scottish Government obviously atop. Scottish Government say that they have remote responsibility for certain organisations. They will include in this things like the NHS and prisons. It's absolute rot, because these organisations are then saying we're waiting for guidance from the Scottish Government. So the Scottish Government have to step up, and obviously schools we've spoken about, they have put this dreadful guidance out. They're saying, oh, it's up to the local education chiefs to deal with. I think with prisons, we've spoken about this, and we've said that if a case is brought against the prisons, it will be against the Scottish ministers. So they really need to sort that out. So I think those big public bodies, obviously, that's where we're going, because that's where we can see that there'll be maximum impact, and it will be relevant to more people. But I think individually there will be people bringing cases against maybe their place of work and so on,
as it has been so far.
Yes.
Not to forget that Reading University has got a list Centaur of an unprecedented number of wins, of successes in ETs and cases that have been brought. So that's a list is written by, I think, Joe Phoenix and another academic.
Yes. And actually, well, you saying that made me think, obviously, universities are going to, I think there's going to be grounds to go against some of the universities. And the other big one, which we've talked about quite a bit, are the unions. We really need more action against the unions, because they've really betrayed female members.
Indeed, comprehensively. Except we just had a little bit from the Royal College of Nursing, who has written a letter about.
Yeah, they've been a bit more useless in Scotland. It seems like whatever happens, whatever's going on in England, Scotland decides to go one better on being useless or extremes.
Just before we move on, we've got a notice from Kathy. Kathy Mudge has got a list of 102 groups, LGBTQ groups, going to schools in UK. We've collected it under our name, Protect and Teach, for their volunteers. So it's happy to share. So that's Kathy. I've got another question for you before we move on to Sally. A question from Lynn Alderson. Lynn, do you want to ask your question?
Yeah, thanks. I just wanted to, you mentioned the GRA reform, and of course it did go through the Scottish Parliament. So I wondered, what is the status of that now? Have we seen the end of it? Does it need undoing? What have we seen the end of these attempts to bring in self-ID in various backdoor ways? So what needs to happen next with all of that?
I don't think there's an appetite in the current Scottish Government to retread this. I think they're quite happy not to have these conversations, because John Swinney is not particularly, I think, signed up to this. Kate Forbes is firmly against it. So I think it's that Lucy can tell you about the legal position on something when the Section 35's been activated, because it's quite a tricky. I think it's sort of left in this strange sort of legislative limbo. But Lucy is the expert on the actual technicalities of that.
So the formal situation is that the bill is in suspended animation. It can't go forward to become a law, which is the process called royal assent, where you stick it under the nose of the monarch and they sign it. Can't move. It cannot move. It's blocked. The only two things that could happen that would change that, one is at the hands of the Scottish government. It would just need to take the bill back one stage. And it could do that. And it doesn't even technically need to amend it. It just needs to take, it's like you're reversing a car. It needs to reverse the car out of the parking space and then move forward. And that would lift the order. Technically, the order would not apply. It's the way the Scotland Act is written. That would just erase the order. And then the UK government would have to come up with another order. However, that requires the Scottish government to go back to the previous stage and vote on the bill again. It requires another vote on the bill, either amended or unamended in some way. So that as Susan says, I mean, you can have technical discussions about what they could and couldn't do. And Kate Forbes has even at some point suggested maybe that would be the way to deal with it. But politically, the appetite at Holyrood to stick that bill back under the nose of parliamentarians, especially now the Labour Party has said that they wouldn't support it. And the problem, it's very hard to solve the problem in the bill that the Section 30, anyway, the court case solves it, but you have other things going on. So it's important to say the Section 35 order didn't just hang on the Equality Act. That was, the big showcase item in the court, it was that, but there were other things. And it's not for, no one can judge, have to go back to a court really to decide if how important those were. So that's one option, which is a political one in Scotland, which could happen tomorrow at the hands of the Scottish government, but weirdly enough hasn't. The other one is technically the Section 35 order is a piece of secondary legislation, which I was asking someone who knows a lot more about it than me about this. Revoking bits of secondary, it's not one that has an obvious revocation process in the Scotland Act, and there are ways to undo secondary, but it's not obvious what they are, and again, then that would be on the floor of Westminster, which I don't think the government there wants. So although technically there are things you could do in either parliament that could cause the bill to suddenly speed forward to royal assent, the political appetite north and south of the border looks so weak. Not because they've got any more hugely more sensible necessarily, but because the public, especially, and the one thing I want to mention is the recent Hamilton by-election. So the Hamilton by-election, John Swinney set everything up as the SNP versus Reform, and only we can beat them, and all that seemed to do was really sort of put Reform in people's minds. Labour comes through the middle and wins, but none, all the votes are very close. 1,500 votes between the Reform candidate in third place and Labour and here, and SNP. It's less than 1,000 votes between the SNP and Reform. So at this point, the political class in Scotland is starting to worry. Because we have an election in 2026, and unlike Westminster, where Reform's disruptive processes and effects are very much on, they won't get places, but they very rarely, but they will disrupt the underlying voting pattern between the parties. Here, we have proportional representation, a list system, and if people are really sort of hacked off with the political classes, what's looking quite likely is that Reform is picking up a lot of people, including possibly people who wouldn't otherwise have voted, who are a really unknown quantity otherwise. And they will, all the pollsters are saying that no matter what, they think Reform are going to have a solid block in the Scottish Parliament. The more that this stuff is up in lights as what politicians are spending parliamentary time on, the more I think, including the Greens, but all the sensible politicians are looking at this and going, this is not good. So that's the context.
Sorry, they just seem to have been spectacularly bad at paying any attention to public opinion, because this has never been popular with the public. So I can just see this bill hanging around like the Marie Celeste, just in the background, waiting until things change. Anyway, I won't continue because you've got lots more to do. Thank you.
Thank you, Lynn. Question from Sam. Sam, you asked a question quite early on, just after Lynn's.
Excuse me.
About the safeguarding. Are you with us still? I'll ask it if you like. She says the safeguarding advice to schools has already changed. Now told specifically not to use the term trans, now told to use gender questioning, which she says this is a positive. My concern remains in the bodies we're referring such youngsters and their families towards. Any comment on that, Susan or Lucy?
Yeah, I mean they're dreadful. Some of those organisations and the schools guidance, which I said is still floating around. They and on a lot of websites they say go and talk to LGBT youth or all these lines and you know I you do not want children going to them or to mermaids. We actually, one of the things that we are also thinking about is because in Scotland, of course, these organisations are funded by public money. They don't have their own sources of income particularly. And one of the things we would like them to look at is whether or not they should be giving public money to organisations that are saying they're going to ignore the law or advising people to ignore the law.
How would you deal with that? How would you get a judicial review, or can that only come after they've given the grant?
I don't know, but I think there needs to be, you know, the ideal scenario would be if they were to write into funding requirements that they have an obligation to provide accurate information on the law, and that they shouldn't be telling people to disobey it. You know, obviously any organisation can campaign for a change in the law, but misrepresenting the law or saying, you know, do what you want all the time, they should not be in receipt of public money. So that's something we've got to puzzle through how we can work on that. Okay,
anybody with answers, put them on a postcard, please, and send them to Forward Scotland. Fiona, I think you've got a question, and that's relating to misrepresentation. Fiona, would you like to ask your question? Great.
Hello, sorry, my family are all over the internet and I kept freezing. So hopefully you can hear this. Thank you so much to Susan and the team for all of your efforts with the case. Oh dear, you've frozen. So I probably frozen.
We can still hear you, I think.
Turn off your camera, maybe, Fiona.
Yes.
Turn off my camera.
Yeah. And
Let's try that. Can you hear me still?
Yes. Fire away.
So sorry. Thank you very much, Susan and the team, for all of your efforts. It's just fantastic. Obviously, you know, us mere mortals couldn't do the same. And for the book as well, I've started reading it. It's really fantastic. So my question was on this weekend on the BBC website, the newscast show with Laura Kunsberg. She interviewed Vicky McLeod, the trans-identifying male who is a former judge. And McLeod, through the entire programme, misrepresented the law. Firstly, repeatedly saying that a gender recognition certificate conferred a change of sex, not gender, that the gender recognition certificate applies for all purposes, which is mentioned in, I think it's, I'm reading up about all these things now, 9.1 or something of the law. Right. But in 9.3 and other places, there are a big list of exceptions, including peerages. You can't trans your way into advantage, unfortunately. Which would allow for changes with the Equality Act. So that seemed to be a complete misrepresentation again. And then thirdly, that I think they meant completely trans women would not be protected in terms of equal pay with men, because, you know, because they were should be considered women, and this would be, you know, terrible infringement. But of course, the Equality Act covers perceived discrimination, so they would be protected from a gender pay gap situation. And this was not challenged at all by the BBC. They let all of these things stand. This has gone out on a BBC broadcast. Misinformation has been just pumped out constantly for 10 years, which has led to this utter mess. And, you know, these aren't small things that can be let stand. This is a former judge who was introduced with great standing because of that and supposed knowledge of the law. What on earth? I mean, I've complained to the BBC, but what else are we supposed to do when people are determined to muddle this up?
Yeah, it's hugely frustrating, and this thing about the for purposes other than the Equality Act, this seems to be one of the new lines that they're running. I would say I don't think one of the things they've been talking about is the 92 workplace regulations, saying, oh, they're not covered, they're not Equality Act. Well, actually, if you have any space or service that is provided on the basis of sex, at some stage you will have to refer back to the Equality Act. Any sort of policy that is based on discrimination, anti-discrimination measures, you will have to refer back to the Equality Act. So this is a bit of a nonsense. They're trying to spin this line that the Equality Act's just this small little thing and it's not important, and everywhere else they're protected, but as their acquired sex. But it's the main thing this was brought in to address at the time, and the only thing actually that you can pin anyone down on when they say this are it is marriage and pensions. And of course, neither of them really apply anymore, because we now have equal marriage and we have an equalisation of pension policy. So it's absolute garbage. And the equal pay stuff is, you know, the majority of time it goes the other way, because the problem we've really had is if highly paid trans-identified men are coming in and being counted as women. That's the real issue. I think we need better educated journalists on this, and we just need to keep plugging away, unfortunately, and telling them what the facts are. But yeah, MacLeod's an ideologue. He's not as bright as he thinks he is. Read his last judgment. It's absolutely insane. I think Maya's got a thread on it.
Right, excellent. I think possibly complain to the BBC.
Yes.
Because they should be picking this up. So that's one thing you could do, Sam, and see how far you get. Because even if they don't take it any further, then if you say you should be doing the homework on this and catching them, because they're so easy to catch, aren't they? I mean, like we saw with the people on the Woman's Hour, it's so obvious that they're misrepresenting things. One last question for you, Susan. Cindy asks, is there any chance that the EHRC will backtrack when they issue their final guidance, given that they seem to have experienced a lot of backlash?
Well, the consultation that they've put out is really just about the sort of examples that they're using, and how things could be, I don't know, better worded or better explained. They can't backtrack on law because the law is what the Supreme Court says it is. So if they were to put out something that misrepresents the law, then we would just take that to judicial review.
Yeah, because they're a public body and they can be JR'd. Yeah,
that's right.
So we might need some crowdfunders for a little while yet. Okay, I'm going to go to Sally now, and we'll come back and tie up all these other things at the end, but we do have to get on. Sally, when this case went to the second division of the inner house of the Scottish Court of Session, now I'm not Scottish, so but I understand that's quite an important senior court in Scotland. They
It's
also,
basically the appeal court.
the
It's
appeal
basically
court.
the appeal court, yeah.
Fantastic. They rejected the submission that treating a trans woman as a woman under the Equality Act would interfere with the rights of freedom of association with lesbians. That was part of the document, that the case documents. Do you want to tell us a little bit about your perspective and how you got your case going?
Yeah, well, I've been concerned for quite a long time, although there was a very small amount in that appeal. I think Baroness Faulkner from the EHRC had written something saying that, talking about gender recognition certificates effectively making men into legal lesbians, and the Court of Session didn't understand it. They said, well, they didn't see anything in the Act that talked about changing people's sexual orientation, and just completely and totally dismissed it. But actually, of course, what the point was that if you were a heterosexual man and you got a gender recognition certificate which said that you were a woman, then you were a woman who was legally a woman who was sexually attracted to women. And that obviously makes you a lesbian. Sort of, that's the definition of a lesbian, except clearly that isn't the definition of that kind of lesbian. But this was the sort of nonsense that we were in. But I think for me, the lesbian question, if you like, was much bigger than that. And one that I don't think has been, it's starting to be more so now, was so well understood within the wider women's rights movement. And I felt very strongly that if we had the lesbian voice heard at court, that would make a really major contribution to the case that For Women Scotland was already putting really, really well anyway. And I was actually, I was moaning about it to Lucy one day. I happened to give her a ride home. Thank goodness she needed a ride home, because in the course of that conversation, she said, have you ever thought about doing a lesbian intervention? And of course, the moment she said it, it was like the penny drop, it was like a light bulb. And it was like, yeah, that's what needs to happen. And actually, in a way, it was really good that we did that, because it gave us 20 pages of a submission rather than just, maybe 20 lines, which is all we could have hoped for in, the very large submission that For Women Scotland had to do. And I think it was really worthwhile, because I think that when you read the judgment, it's really clear how important the lesbian argument actually was, running throughout it. I think it's difficult for women who haven't been involved in sort of lesbian lifestyle to understand, well, a couple of things. One, we were really in the front line of this gender ideology nonsense in a way that wasn't so public. We had a lot of talk about toilets, but what you didn't hear about was the way that lesbian culture and social life had been completely destroyed, because all the things that we ever did on our own as women, as lesbians, now had men coming in, waving their bits about, saying, well, we're lesbians too now. And over, when I was growing up as a sort of young lesbian, I was in a big lesbian community. I lived in a lesbian housing co-op. We lived a lesbian lifestyle, which really doesn't exist anymore. And I think even younger lesbians today growing up without that don't recognize how important it is. And that's one of the reasons, for example, why we started Lesbian Persistence, was to try and create that sort of start to regrow some sort of lesbian community. And we had, for example, men turning up in all the lesbian dating. So this is the one thing actually that I think the wider women's rights movement did understand, was that we were expected to include men in our dating pools. And certainly that was true. You can't go on a lesbian dating app now. I don't, but many of our members do, without it being absolutely full of men saying that they're lesbians. And, we've been told by quite a lot of women that if they said that they were only interested in biological female lesbians, i.e. what I would just call lesbians, then they would get thrown off the apps, because that was transphobic. But more broadly, we had been told, I think, that I was always being told, when I tried to raise the question of the lesbian perspective being different, that, well, apart from the dating stuff, you're just a subset of women, and there's nothing special about the lesbian story. But I think that's not really true. And I want to say a little bit about that, which is not directly related to the case, but it's part of the reason why I felt it was so very, very important that we did have this lesbian perspective, which is that, if you like, the case that was most widely made is about situations, like say you have, you know, toilets or changing rooms or hospitals wards or prisons, or, you know, even disabled women who are in need of intimate care. But these are all situational. You know, you need single sex services or single sex spaces in these specific situations. And when that situation doesn't any longer apply, you know, you get out of prison, you don't need to pee any longer, whatever, then it all becomes sort of less relevant. Whereas for lesbians, for or at least those of us that are sort of second wave lesbian feminists who wanted to live in this more sort of lesbian cultural life, it's foundational. It's part of what we want to be able to do all day, every day. So for example, you know, if we want to have a lesbian disco, I don't want to exclude a man who says he's a lesbian because I feel unsafe. Well, I suppose if I use the trans definition of unsafe, then, you know, I would be dead if he came in, because clearly, you know, being in a space with somebody I don't agree with would be fatal. But I mean, in the normal use of the word, unsafe, I you know, I don't feel unsafe if he's standing prancing around in the middle of the dance floor. But it stops it being a lesbian disco, because it's no longer a women-only space. It's no longer a lesbian-only space. It's now a mixed space. And I just want my right to be with other lesbian women. And I, you know, for other women who want the right to be with other women in other situations, not necessarily lesbians, that should be enough. Just the fact that that's how we choose to live our lives. It's sort of binary. There's either a man there or there isn't. You know, it's either single sex space or it's a mixed space. There is no halfway point. There's no compromise possible. And quite often, of course, the man in the middle of the lesbian disco isn't just any old heterosexual man who wants to be there. He's a heterosexual man with a particularly unpleasant sexual fetish. So he's definitely the last sort of person that we would want to have in our spaces. And as an aside, I think Susan, I want to pick up something that Susan said, that gender identity ideology, I think, at its heart is a very misogynist and lesbophobic men's rights movement. And all the rest is just on top of that. I think it's really important to remember that lesbian is now the second most searched for porn category. And, you know, you might have heard talk about that, and a lot of young women don't want to define themselves as lesbians for that very reason, because they see it as a porn category. So they call themselves queer or non-binary or gender fluid or something else or bisexual instead. And that men's rights movement is one which claims that men are entitled to whatever they want, wherever they want, whenever they want. And to my mind, there's no greater proof of that sense of entitlement than the fact that they think that if they turn up to a lesbian disco in a skirt, metaphorically or literally in a skirt, that entitles them to come into our spaces and entitles them to demand that we recognize their entitlement as well. I mean, it's just all about male entitlement. And I was very happy. In fact, I was fairly confident that we'd won the case when, during the discussion in court about lesbian issues, one of the judges picked this up and said, you know, what if lesbians just wanted to meet with other like-minded women? Which was a point that was rather lost on the poor barrister. You had to feel a bit sorry for Ruth Crawford, who was the Scottish Government barrister, because she was doing her very best in a very difficult situation. She was, you know, given a ridiculous case to argue. And I think you asked about, you mentioned about her saying things which was contradicting what the Scottish Government had said. Well, the difficulty she found herself in is that as a lawyer in court, and particularly as a lawyer in the Supreme Court, which is the highest court in the UK, she is actually obliged to talk the truth and to speak what the law actually is. Unlike the Scottish Government, who were quite happy quoting Stonewall law left, right and centre and could get away with it with no trouble at all. So despite the fact that, you know, the importance, if you like, of our foundational need for proper single-sex lesbian facilities, the case we made to the Supreme Court was a legal, not a moral one. And it was based on our legal rights and not our feelings. But it was very, very useful in illustrating the utter absurdity of the mess that the law was in if Scottish Government interpretation was allowed to have its way. Actually, just also, it's worth saying that some of the discussion, there was quite a brief discussion, 10 minutes, maybe 15 at the absolute most, in the second afternoon of the court case, where Ruth Crawford was discussing sort of the lesbian question and the issues we'd made in our intervention with the judges. And it's absolute comedy gold in places. And if you want a good laugh and you really want to understand just how ridiculous things had become, you know, take 10 minutes, go away and find it and watch it. Susan's smiling because it was just, I mean, it was really difficult. You know, we were sitting in court behind them. We weren't allowed to laugh. But I think people in the overflow room watching on a screen probably did. So the Equality Act protects women on the basis of our sex. And it protects us as lesbians on the basis of our sexual orientation. And when they were making their decision, the judges considered the core provisions of the Equality Act, including, of course, sexual orientation. Now, at one point, Ruth Crawford was having to argue that it was absolutely fine for men to be called lesbians because we, lesbians, wouldn't be affected by such a definition because it wouldn't stop us being lesbians. And as no woman is attracted to, you know, all other women if she's a lesbian, or all other men if she's straight, you know, so we didn't need to be attracted to every lesbian, and we didn't have to be attracted to the lesbians who happen to be male lesbians, and that would be just fine and dandy, and there would be absolutely no problem whatsoever. So Lord Reid, who's the president of the Supreme Court, and he was chairing this panel, which I think is a measure of how important the case was seen in the Supreme Court, by the Supreme Court. He was chairing the judges panel, and he asked for clarification. He said, well, so a trans woman, as he called them, a trans woman, a man, in other words, with a gender recognition certificate is to be treated as a lesbian. Yes, says the barrister, but treated as a heterosexual man if he doesn't have a GRC. Yes, says the barrister. So he says that difference is pretty stark. And the barrister then agreed that only a person, I think she meant a man, only a person with a GRC is a lesbian because he has the acquired sex of the opposite gender, whatever that means. Whereas a man without a GRC is not a lesbian because they've not acquired the sex of, and she sort of trailed off there because I think it just became completely impossible to continue that conversation. So, you know, just even the conversation around it demonstrated how ridiculous it was. And I had found an absolutely brilliant legal team. Well, talking about the intervention, you know, Susan was saying about Whittle and what's his name?
Cloud.
Victoria Thingybob,
McLeod.
Yeah, complaining that they weren't represented in court. Well, I personally can attest to the fact that individual people are not allowed to, you know, make a case at court, because despite the fact that I had put the whole intervention together and, you know, got the voluntary organisations, the lesbian groups, and got the legal team and everything, I wasn't actually a member of any of those lesbian groups. So I asked, could my name be added to the list of interveners, and was told no, because you couldn't do that. You know, you had to be representing somebody. So my, you know, I don't have any sympathy with McLeod and Whittle because I was in the same position. So I know that it's true. But anyway, we had this brilliant legal team. So Karen Monaghan Casey was our barrister, assisted by Beth Grossman. And they weren't given permission, unfortunately, to make an oral submission. So, you know, a lot lay on the written submission that we made instead. And they did an absolutely exceptional job, I think, it's fair to say, of researching all the cases. There was very little case law, it turned out, either in the UK or in Europe, that addressed specifically lesbian questions, but that which existed demonstrated quite a strong pattern of discrimination against lesbians, and famously the fact that lesbian mothers, including actually at least one friend of mine back in the 80s, were lost custody of their children at a time when mothers always got custody of their kids, because being a lesbian was seen as such a terrible thing, that children were seen to be safer with their fathers. Very often, although not in my friend's case, fortunately, but very often, even when the men concerned were abusive and violent. So there's three kind of key areas, I think, of the judgment relating to lesbians that's worth mentioning. So firstly, what does it mean to be a lesbian? And again, Susan made sort of passing reference to this. If you take, bear with me, if you get lost, don't worry. That's the kind of, trigger warning before I start this. If you take the Scottish government definition of who is a woman and therefore who is a lesbian, then a lesbian would be defined in court as a woman who's sexually attracted to other women, so long as she herself doesn't have a gender recognition certificate, but also who is attracted to men who do have a gender recognition certificate, because they are then lesbian. Well, they are then other women. And the flowchart came in because, but also it would exclude. Sorry, I forgot a very important point. It would exclude women who were lesbians but who have a gender recognition certificate, because they would then be defined as heterosexual men. And of course, they are a very large percentage of the women who get gender recognition certificates. They are actually lesbian women who for societal reasons and because of the patriarchy and stuff, are kind of pushed into defining themselves as men instead. Very much a case of transing the gay away, I think. So that actually leads to all sorts of other problems. So if you take the case, for example, of Theodore Upton, Dr. Beth Upton, as he's better known, he says he's a lesbian. Well, he says he's a woman and he's in a relationship with his wife. So then the question becomes, well, so his wife is in a relationship with a woman now. In fact, he doesn't have a gender recognition certificate, so it doesn't apply, but let's, for the sake of argument, pretend that he or somebody in similar position does. So his wife is then in a relationship with a woman, in inverted commas, who claims to be a lesbian. Does that make the wife a lesbian? And what about if you have two men who both have gender recognition certificates and call themselves women, and they're basically in a gay male relationship, but they both call themselves women? Are they then lesbians? And it was a question about one of these sorts of couples that was asked, which led the Scottish Government barrister to say she'd have to consult the flowchart, I think, to work out just exactly who is a lesbian. Now, you call me old-fashioned, but as far as I'm concerned, a lesbian is just a proper woman, a biological woman who's attracted to other biological women. It's really very, very simple. And I've never needed a flowchart to work out who is a lesbian or who I am supposed to be attracted to or allowed to be attracted to. So because of all this nonsense, there was actually a paragraph in our submission where our barristers explained the basic facts of being a lesbian, which you wouldn't have thought was necessary. And it read, it barely needs stating that lesbians are females who are sexually orientated towards the bodies of other females. Again, it barely needs stating that there are anatomical differences between males and females. I mean, who would have thought it was necessary to put this in a submission to the Supreme Court, right? The defining characteristic of a lesbian is that she is not attracted to male bodies, including penises, testicles, male body mass, and shape. Nor is she sexually attracted to certificates. And when I read that, I just roared with laughter. I absolutely loved it. It was my favorite line in the entire submission. And in fact, it made such an impact that it found its way into the final judgment, because the judgment itself actually stated people are not sexually oriented towards those in possession of a certificate. So that's now the law of the land, that we don't have to be attracted to certificates. So that's quite handy. So defining sex as certificated sex as opposed to biological sex would have led to the absurd position, which actually, of course, we've been facing for years and years now, that biological men could become lesbians. And that was definitely an ask too far, I think, for the judges, who simply could not accept that a biological male could ever become a same-sex attracted female. And again, in their ruling, the judges completely accepted the argument that we had made in the lesbian submission. And one of the points that, again, I think has been referred to earlier in the discussion today, that was referred to in the judgment, was the need for a legal interpretation that is both consistent and coherent. I mean, to the point that actually in the pub afterwards, I was talking to a couple of lawyers who were saying, has coherence just been introduced as a new legal test of the law? Because it was used so often, the terms, the need for things to be coherent was used so often in the judgment. Again, it's worth it if you read it, bearing that in mind. And a certificated definition of sex would lead to incoherent groups. So, for example, it would mean basically what I said, that a lesbian was a biological female without a GRC, or a biological male with a GRC who's legally female, who's attracted to women without a GRC or to males with a GRC. Women themselves with a GRC who are legally male wouldn't be lesbians, and so on and so forth. And that grouping then of people called lesbians would create a completely incoherent group. You could never know who was or wasn't a lesbian. And at the very, very least, it would be impossible to identify who was or wasn't a lesbian without knowing somebody's GRC status. Secondly, and very closely related to that, is the question of what the impact of the competing definitions would be on the meaning of sexual orientation. Because it's very important to understand sexual orientation, because it's a protected characteristic within the Equality Act. And you can't protect something if you don't know what it is. And a certificated definition of sex would have meant, and again, I'm going to just read briefly from the ruling itself, that a trans woman, a biological male. I love the fact that every time they referred to a trans woman, they put in brackets afterwards for the avoidance of doubt, a biological male. They were just banging the point home that a trans woman, a biological male with a GRC, so legally female, who remains sexually oriented to other females, would become a same-sex attracted female, in other words, a lesbian. The concept, and this is the crucial bit of this, is that they then said the concept of sexual orientation towards members of a particular sex is rendered meaningless. So it's very, very important that if you let men be called lesbians, then the term homosexuality becomes completely meaningless, which in turn would render the Equality Act protection of sexual orientation unenforceable, because you can't protect something that doesn't exist or that can't be defined. And this was a very important point in pointing to the need for a definition of sex as biological, because otherwise it made a nonsense of the Equality Act. You know, why would Parliament have legislated to protect people on the basis of their sexual orientation if such orientation was effectively meaningless? And the final point in relation to the question of certificated versus biological sex that was really, really important was that of lesbian associations. And just briefly, an association is defined in the Equality Act as being a group, a membership group of more than 25 people. So it would, for example, include lesbian persistence, because we've got at least double that number. And the Equality Act allows for the creation of an association of people who share one or more protected characteristics. So you can have a group for lesbians and gay men, where all members share the protected characteristic of same-sex sexual orientation. And you can have a lesbian-only group where members have two protected characteristics, that of sex and of being same-sex attracted. But the ruling concluded that a certificated interpretation of sex would also affect who you could let into your group, because we would have to let in a trans woman with a GRC and who would be treated as a lesbian. In other words, we would be forced to admit men. But one of... Yes?
Carry on. I've got a question for you, but do carry on.
Oh, yeah, sorry. I just saw you put your hand up. Sorry. Yeah. But the point was made several times by the judges that the only way we can tell the difference between so-called lesbian males, i.e. those with a gender recognition certificate, and the heterosexual men who LARP as women but don't have a gender recognition certificate, is actually to ask to see the GRC. But as they kept pointing out, we're not allowed to ask to see the GRC. So in practice, in order to comply with the law, we would have to let in all men who self-identify as lesbians. And Lady Simler suggested during the hearing that this would have a chilling effect on lesbian associations, although the point was somewhat lost on the barrister. Far be it from a mere mortal like myself to question the wisdom of the Supreme Court judges, but actually I think they were mistaken. I think we are allowed, my understanding is we are allowed to ask to see a GRC, but having asked to see it, having seen it, we're not actually allowed to do anything with the information, because you're not allowed to tell anybody that you've seen it or that the person has it. So it kind of comes to the same thing in practice, but just on a minor technicality. We are allowed to ask, I can ask to see your GRC, but then I can't tell anybody I've seen it and I can't do anything with the information. So kind of comes to the same thing. And again, the judges considered that using certificated sex, which would allow really any man who wants to say that he's a woman as a lesbian into our groups, couldn't possibly have been what Parliament intended. So the Scottish Government tried to offer a range of what they called solutions to the lesbian association question. One was to suggest that it was perfectly all right because being gender critical or believing in the immutability of sex was a protected belief. So we could form an association of lesbians who held the protected belief in gender critical belief, if you like. Which clearly is nonsensical. And in fact, it was that prompted Lady Similar to say, yeah, but what if they just want to meet with other like-minded people, you know, women, like that we shouldn't have to have a belief system in order to meet. And also it would have, of course, it would have meant that lesbians who wanted to meet without being gender critical or being in a gender critical association wouldn't have been able to do so. And the second suggestion that the government made was that we should stick to just having small groups with less than 25 members, and then we wouldn't be subjected to the requirements of the Equality Act. And the court's riposte to that was what I think you might call short and sharp. They said, it is unprincipled to argue this problem, to answer this problem by saying, as the Scottish ministers do, that associations can restrict membership to less than 25 members so that they are not an association for the purposes of the Act. It's also impracticable. So that again it is very important. You know, the Scottish government was so used to talking absolute rubbish. I'm trying to find a polite word. I'll settle for rubbish, and getting away with it. And I think they're probably quite shocked to discover that it just doesn't wash in front of, you know, some of the sharpest legal minds in the UK. So the most important point of the ruling for lesbians are, one, men cannot be lesbians. Who knew? I'm so glad to have that explained to me by the Supreme Court. I was never quite certain.
But you've got it in writing now.
I've got it in writing now. It's official. Men can't be lesbians. Secondly, and very importantly, that men with or without a gender recognition certificate have no right to enter women's or lesbians' facilities or spaces, whatever they are. The other thing that I think hasn't been mentioned is that no men can apply for jobs or other posts designated as being reserved for women, which has happened a lot in the past.
In Edinburgh, particularly.
In Edinburgh, yes. In fact, I think the speaker that you mentioned earlier had particular personal experience of that, Ros Adams.
Indeed.
The Rape Crisis Centre. As I've said, that lesbians have the right to meet without men. So we're allowed to form lesbian-only clubs and associations such as Lesbian Persistence and other things. You know, my lesbian walking group can go on being a lesbian-only group without having to worry about whether we need to let men in. The lesbian book group can go on being a lesbian book group without having to, you know, for the past 10 years, we've been meeting underground. We've been sending each other secret messages. We've not been advertising our spaces and our events and our groups publicly because although we always said that we had the right to do this, you know, we were subjected to you know, at worst, you know, hatred and threats, and at best threat of you know, threats of violence and possibly even the threat of legal action if we were seen to be organising as a women-only group. So I could go on, but you had some questions, so let me pass over to you.
I think that last point, we've only got a few minutes before we're going to have to finish, but I think one of the serious questions is if Jolyon Morn and the Good Law Project are talking about taking a human rights case to Europe, aren't your human rights as important as the human rights of their clients.
Well, you would hope
This is-
so, wouldn't you?
This is to all of you now, all three of you.
Well, you would certainly hope so. I mean, I think, you know, women in general have been ignored when human rights have been discussed in this context, and lesbians haven't just been ignored, they've been completely and totally invisible. And, you know, most conversation about lesbians coming from the other side has been about, you know, male lesbians, you know, and the rights of men to define themselves as lesbians. I mean, certainly, I think it's very unlikely, not that I'm a lawyer, but I was listening to Akua Reindorf the other day talking about this, and she was saying she couldn't see any route at all for him to go to the European Court, anybody to go to the European Court. But I mean, if they, I think the case that Jolene Morm's trying to take is here, but it's nonsense. It's got nowhere to go, in my opinion, and certainly, you know, if they do try and take a case, we'll be wanting to make a lesbian case about our human rights and our right to. It's about our right to freedom of association, which is, you know, written into the Human Rights Act, or
I think
the
Articles
Universal
8,
Declaration of
11
Human
and
Rights.
14.
Yes. Because the difference, I think, between us and them, so the other side, so to speak, is that, you know, we've never objected to trans organizations existing. I mean, they've always said, you know, there's no LGB without the T, but there's been an awful lot of T without the LGB. Well, I'm quite happy for that. You know, that's how I think it should be, T on one side and LGB on the other. Because really they're nothing to do with each other. But I do think that this is a really important ruling for establishing in UK law that lesbians actually do have proper human rights and legal rights, in some ways for the first time. And I think, you know, that there's a lot that's going to rest on this. Before we finish, I want to say something about the EHRC consultation as well, if I can have 2 minutes to do that. It is now okay.
Now
I
last chance.
Okay, fine. Well, there's an awful lot of stuff in the EHRC consultation, which is, I mean, the consultation is about the new code of practice, which they've got to issue in light of the ruling, whose function is to help organizations understand how they can accurately implement the law in their circumstances. But when we've looked at it, and we're in the middle of writing a response to it, we're very, very concerned, and I haven't seen other people speaking about this, about a lot of the language that's used. I mean, Susan was talking about if they do things illegally. There's certainly some of what they say about sports, we think is a complete and total misinterpretation of the Equality Act, and we'll certainly be questioning that. But also, it's absolutely full of, you know, if you want to run a single-sex service or whatever, you can check whether potential users are men or women. You can ask them what their sex is. But it is full, every single paragraph of that discussion is full of different terms. You know, you have to do it sensitively. You have to do it in a way that doesn't harass somebody. You have to do it in a way that isn't discriminatory. You have to do it in a way that doesn't upset somebody. My colleague is making a list. I think there's about 10 or 12 different phrases that they use. Now, the terms sensitive and even harassment and discrimination in that context don't appear in the law. And we're concerned that in the sense that the code of practice has quasi-legal status. I mean, it's a legal document, but people, organizations and the courts only have to have regard to it. They don't actually have to follow it word for word. But nevertheless, as it's written, we think opens up the way for, you know, any bloke, because we know how sensitive and delicate people's feelings are, you know, that any man who's asked to prove whether he's a man or a woman is simply going to be able to take a case to say that the code of practice was not followed, that, you know, it wasn't done in a sensitive way. And even if they're going to lose, it's still, all these things are, it's written in a way, if I was reading, when I read it, I thought, if I was a provider, I would never, ever, ever ask anybody what their sex was. I'd just let anybody in, because it just creates barrier after barrier after barrier. And so my plea is to anybody here who's responding to the consultation, or who isn't yet responding to it, but thinks that maybe they could be persuaded to raise this as a very serious issue, because it's talking about chilling effects. The terminology, I think, has a very serious chilling effect on providers. I don't know if Susan's got anything to say about that.
No, I agree. The sports section's weird. It's and there's I think that the issue is it shouldn't be on providers to deal with the law. We just need clear statements. This is what the law is. It says you've got to go in that space if you're male, that space if you're female, and you know, and that's the law. Bottom line, that's the law.
You'd think
Now-
it was simple, wasn't it? Back in the day, we all used to know who a man and a woman was, and we didn't need police at the door because they self-policed. The men
No.
went that way and the women went that way. It was really easy.
There was a question that Robin White put forward on Woman's Hour that mums wouldn't be able to take their little boys into the ladies' lavatory.
You're like,
Well, that was
Gosh,
stupid and
thank you,
nonsense.
yeah.
Sorry, Lucy. You,
Oh,
I know.
Thank you so much, Lucy.
sorry, it's just very quickly, just I was to come in on a few comments there, but I'll come back to Robin and his mad comment there. But
Fantastic.
But the point I want to make is that we're all massively ahead on the law here. And I think what you see when you follow the Supreme Court stuff is that people, journalists, cases like, you know, Helena Kennedy, who doesn't understand the perception test, and we've all become self-amateur, but very good. You know, we need proper lawyers, and thank God for the ones we've got, but we've all become good clients for lawyers, put it that way.
Yeah.
We've had to, we've really had to, and you see that in the difference. And if there are more legal cases, or if the code isn't right or whatever, the readiness of women, you know, if someone, the other side brings a case, we can intervene.
Yes.
It's a lot cheaper and easier to be an intervener than it is to bring the case. So, you know, on one level, I'm quite relaxed if they do get through the first hurdles for a case, because I can tell you now that there'll be a range of women in there. On the lose point, it's just mad, isn't it? Because this is about women going into the women's lose and happening to have a boy with them. The idea, so I mean, my line is, if Robin wants to arrange with his mum for her to take him into the loo, we can deal with that. But at a serious level, this is actually very important, because we keep seeing very normal conventions of work for women, so you can take your little boy into the loo. And because no one wants to send a 5-year-old boy alone into the gents, many mothers get very anxious, you know, when they start having to send a boy into the gents, 8, 9, whatever, or even younger. They hate doing it sometimes. They worry. So this is about this is, if we can't get in, nothing else can happen. And we have to be so resistant to these kind of marginal snippings away using sort of sophistry of law. We have to, and we'll have to keep fighting. And I suppose that's all we see now is what the new arguments are. But we are so far ahead of the game on our side of the argument.
Because we're used to making
I did
cogent
see
arguments.
something on that small child argument,
Yes,
and it was
yes,
very
good.
much that because that part, because the provisions around toilets, for example, will concern privacy, dignity, safety, and safety being a key. A small child does not pose a risk to those things, so it does not apply to them in the same way it does an adult man. So it's quite an easy one.
Fantastic. One question I'm going to ask David your question. How did the Scottish courts get it so wrong? You know, because here the Supreme Court has been able to listen to the cases and get it right.
I think to some extent they didn't want to rule on it, and I think that's why they were so keen for it to go to the Supreme Court, because this is a piece of UK legislation. I think there's something that, but also you've got to remember Civic Scotland's quite small and there's a lot of interconnectedness.
Yes, everybody knows
That's
everybody.
a diplomatic way of saying it.
Yes, and there's the Upton Sinclair feature as well. You know, it's amazing how difficult it is for people to understand something when their job depends on them not understanding it. Has anybody got one last question? Because we do have to pack up now. I know people have got time constraints. If not, I'm just going to say. Oh,
can I just make one comment?
I wish you would. So just
okay. It's policy and law based. They were always telling us before that lots of men passed, and in fact, the Goodwin case, which started all this trouble, was a complete farce, because it was a case in Strasbourg, and it was said that this man passed, and then everybody's dug up a video of him talking to the BBC or someone like that, driving a bus, and he looks like a hatchet-faced man in a wig, tall, and his voice is male, of course. So what I just want to say is all this stuff about how do you tell a man from a woman? We must fight back about this. You spot them instantly.
Indeed.
All this passing is nonsense, and it also, as they do come into the sort of foreground in these legal cases, we must make sure that we're constantly making the point, as with Robin Moira White, once you get a good look at him, well, not even a good look at him, he looks like a man.
Yes, of
So
course.
don't let anybody do this passing thing on you, or how do you tell which is which? It has always been nonsense.
And we're
that
allowed to draw our own
case was a
conclusions
scandal.
from the evidence of
Yeah.
our own eyes, aren't we?
Yeah. He
Yeah.
obviously didn't go to Strasbourg, and the judges didn't look at him.
No. Thank you. On that note, I think we're going to have to call it to a halt. We could have gone all night, ladies. It's been so interesting. I've had a wonderful time listening to you, telling us these stories, and been some great questions. I haven't been able to get to them even. In fact, Catherine says, is it time for another judicial review in schools? You have to think about that. But I'd like to say thank you to Rachel, my colleague, for managing the event for Liberal Voice Women. We aim to put the talk up on our YouTube channel as soon as possible. Thanks for all your great questions and comments, and thank you, ladies, for coming to speak to us. We'll next meet on Monday, the 14th of July, that's a Bastille Day, when our guest will be Michael Conroy of Men at Work, postponed from May. So do look out for the announcement or sign up to our website, Liberal Voice of Women, and we'll send you the invitation. I think it's going to be the same invitation as it was in May. I don't think we have to change that. I'm not sure. But anyway, we will be publicising it again. And we'll also want to hear from you, any of you, with any policy-related issues or problems that you want us to raise, including the question about the letter from ALDC about policy. We are going to be pushing back on that, just so in case those of you who are councillors wish to know. But thank you all so much, and I wish you all a very good night, and sleep easy in the knowledge that the law is in safe hands in Scotland and in Westminster. Thanks very much.